So today, we're going to demystify the trial process for what the law calls warrant cases. Now, the serious criminal stuff. But here's the interesting part. We're focusing on cases that are started by a private citizen, not by the police. And we'll be using the brand new rulebook for this, the Bharatiya Nagarik Suraksha Sanhita, or BNSS, to guide us through the whole journey.
Okay, so what exactly are we talking about here? Well, imagine a serious crime happens, but for whatever reason, a police report, an FIR, doesn't get filed. A private complaint is how a regular citizen can bypass that and go straight to a magistrate and say, hey, a crime was committed, and I have the proof. That single action is what kicks off this entire legal roller coaster we're about to explore.
Here's our roadmap. We've structured this whole thing like a play in 4 acts. We'll start with the prosecution's opening, then we hit a major decision point. After that, the trial really gets going, which leads to the defense's big response. And we've even got a little subplot. What happens when the person who started it all just disappears? This should give you a crystal clear picture of how it all unfolds.
All right, let's get into it. Act 1, the prosecution's opening. The curtain is up, the accused person is in court, and this whole process is guided by Section 267 of the BNSS. This is where the wheels of justice officially start to turn.
So, the very first step is actually pretty straightforward, but it sets the stage for everything else. The magistrate's only job right now is to listen. They hear out the person making the accusation and look at all the initial evidence they brought to back up their story.
So, this opening act really boils down to 2 key things. First, the prosecution lays out its cards, presents its case. Second, and this is a really powerful tool, if they need someone to testify or they need a critical document, they can ask the court for help. The magistrate can then issue a summons, which is basically an official order demanding that person or document shows up in court.
And this idea is built on a really important principle that's been around for ages. A case from way back in 1964 confirmed that the court isn't just a passive referee. No, it's an active player in the search for truth. If there's a witness who could clear things up, the court has a duty to bring them in.
And that brings us to Act 2, the critical crossroads. This stage, covered by Section 268 of the BNSS, is the first huge fork in the road. Here, the magistrate has to make a massive decision. Does this case move forward, or does it all stop right here?
The one giant question the magistrate has to answer is this. Based on what I've seen so far, is there actually a case here? Is there enough meat on the bones to justify putting someone through a full-blown criminal trial?
What's really key here is that Section 268 gives the accused 2 potential off-ramps. The first way they can be discharged or let go is if, after seeing all the initial evidence, the magistrate just doesn't think there's enough to build a case. The second way can happen even earlier. If the accusation just seems totally baseless from the get-go, the magistrate can dismiss it right then and there.
Now, the Supreme Court weighed in on this in a really important case, Rakesh Kumar Jain versus State. They made it super clear, just because there was a delay in filing the complaint, that's not enough reason on its own to throw the case out. If there's a good explanation for that delay, the case should move forward. It really shows that the substance of the case matters more than just timing.
Okay, so if the case survives that critical crossroads and isn't thrown out, we move into the main event, Act 3. This is where the trial officially kicks off, guided by Section 269 of the BNSS, and it all starts with framing the charge.
This is the moment it all gets very, very real. If the magistrate is convinced there's a strong possibility the accused committed the crime, they make it official. The specific offense is put down in black and white. It's not just a vague accusation anymore. It's a formal, written charge.
Section 269 lays out a very clear and fair sequence of events. First, the charge is framed. Then, it's read out loud and explained so the accused understands exactly what's going on. They're asked to plead, guilty or not guilty. If they say guilty, it can all end right there with a conviction. If not, they get the chance to question the witnesses who have already testified. It's all about making sure the defense knows exactly what they're up against.
Now, 2 really crucial legal principles control this stage. First, a case called Ratilal Banji Mithani established that once a charge is framed, that's it. The magistrate can't go back and discharge the accused. It's a point of no return. Second, an even older case set a vital standard. A guilty plea only counts if the court is totally satisfied that the accused truly understands what they're admitting to.
On to Act 4. The prosecution has made its case, the charges are official, and now the spotlight swings right over to the defense. This whole part of the trial is governed by Section 270 of the BNSS.
So now,
The tables turn. It's finally the accused's chance to tell their side of the story. They are officially called to present their defense. This is their shot to bring in their own witnesses, submit their own evidence, and do whatever they can to poke holes in the prosecution's story.
But, and this is a big but, this right isn't a blank check. The court can actually say no to calling a defense witness, but only for a few specific reasons. If the magistrate thinks the request is just meant to annoy someone, or to drag out the trial forever, or if it would actually get in the way of justice, they can refuse. The goal here is a fair trial, not one that can be played with.
And now for our interesting subplot. What happens if the person who kicked this whole thing off, the complainant, just doesn't bother to show up for a hearing? This is a real-world problem that courts deal with all the time, and Section 272 of the BNSS tells us what to do.
I mean, it's a great question, right? Their complaint is the whole reason everyone is in court. So if they're a no-show, does the case just fall apart? Well, the law has a very specific and conditional answer for exactly this situation.
Yes, the magistrate can discharge the accused if the complainant is absent, but, and you gotta listen closely, only if all 4 of these conditions are met. The offense has to be compoundable, meaning it can be legally settled between the parties, and it must be non-cognizable, which usually means it's a less serious crime. If the case doesn't check all these boxes, the trial can continue even without the complainant.
And that brings us to a final, absolutely critical takeaway. The Supreme Court has made it clear, if a case gets dismissed because the complainant didn't show up, that decision is final. The magistrate can't just change their mind and reopen the case later. At that level of court, the door is shut for good.
So there you have it. We've followed the entire journey, from the first complaint right through to the final defense. Now that you've seen all the stages, the initial hearing, that critical decision to charge or not, the trial itself, what do you think is the single most important protection for the accused that's built into this whole process? Something to think about.